Hi, everyone. Welcome back to the channel. Tony here with Italian Dual Citizenship Assistance. And in today's video, we're going to take a look at potential options for those blocked by the recent changes in Italian citizenship law. And we're going to take a look at what we know as of today, May 2nd, Friday, May 2nd. And the big things that we're waiting on are understanding if this decree law is going to pass, is it going to be converted into law? And along with that, is it going to change in some way? Is it going to be modified? We know that there have been many amendments proposed to the decree, and those amendments are being reviewed and voted on. They started that process in the Parliament on April 23rd. So we should have a lot more information coming up in the next week or two. But in the meantime, as I'm having consultations with people, everybody's trying to figure out what their path forward looks like, all of the people that are blocked by the current elements of the decree. So let's take a look at some of those potential options that we may have moving forward and get you to start thinking about setting yourself up to take advantage of these options. So in today's video, we're going to look at your potential options for those who have been blocked by these recent changes in citizenship law. We're going to break it down. We're going to cover what's actually changed, who it affects, and most importantly, what we can still potentially do. And as always, I give you my disclaimer that I'm not an attorney. I'm not an Italian attorney, but I do speak regularly with some of the top Italian attorneys who help me present you the latest and greatest information on what's going on for you here on the channel, as well as for my personal clients. So moving forward, what we know now is that the decree law is in place. This restricts some eligibility for many people. The decree law 36 is in the process of being converted into law. There are 60 days given for this process. It either has to be converted or it goes away. It's being converted. It's being reviewed by Parliament under Bill DDL 1432, which is the conversion bill to convert Decree Law 36 into law permanently. Operations are beginning to resume after temporary shutdown of applications and appointments at many of the consulates in Comuni. And we've also seen Bill DDL 1450, which has been proposed as the long-term plan for citizenship laws, designed to be a much more all-encompassing longer-term plan that may likely add to or replace elements of the decree law moving forward. Now, I did a complete video on DDL 1450, so check out that video if you haven't seen that one already for more information on that. But we do know that DDL 1450 really has not been looked at yet. All of the focus has been on Decree Law 36 and its conversion bill, DDL 1432, to this point. As I mentioned, we've had 106 different amendments submitted and are being reviewed and voted on. We've got amendments that are looking to completely eliminate all of the restrictions of the decree. Some amendments would extend eligibility windows out, which would help people a lot. People would be able to apply under the old rules out to a certain date in the distance instead of it starting immediately on March 28th. Some of the amendments seek to restore automatic transmission of citizenship to minor children, which has been a big concern. Another big concern is the 2-generational limit. Some of the proposals aim to broaden eligibility out through great-grandparents and potentially beyond. So we've got a lot of amendments that are seeking to relax the restrictions in the decree. And we're also seeing a lot of significant political momentum aimed at softening or amending the decree. Even inside the governing coalition, we're seeing members questioning parts of the law and questioning whether or not the decree is too extreme, too restrictive. So I also did talk about these amendments in a previous video as well. And we'll definitely be keeping an eye on what happens with those amendments and the voting on those over the coming week. So what's changed? We have to talk about the recent changes in the Italian dual citizenship by descent process, we really need to go back to a little over 6 months ago to the October 3rd circular, which was kind of the formal introduction of the minor issue, which is blocking a lot of people. So we're going to discuss that element as well as flashing forward here to the March 28th implementation of the emergency decree, which limits eligibility to those with an Italian parent or grandparent born in Italy, or to those with an Italian parent who resided in Italy for at least 2 years prior to your birth. It also introduces some vague effective ties to Italy requirements. This is emphasized in the preamble, but not defined specifically in the articles of the decree. And Decree Law 36 also ends automatic transmission of citizenship to minor children unless they meet the eligibility requirements independently. And it actually declares applications filed in Italy to be only admissible if the applicant has resided legally and continuously in Italy for at least 12 months prior to applying. So that marks a significant change over the process of applying directly in Italy that has been in place for a while now, where most people could expect to have to remain in Italy for about 3 to 6 months to complete the process. Now we're looking at needing to live in Italy continuously for 12 months prior to even applying. So we've identified here four main categories of people that are blocked by these recent um, law changes, including the minor issue, which plays into DDL 1432, the conversion bill, as we're all looking at this bill converting the decree into law and the subsequent bill DDL 1450 that's on the table and what that might do for the minor issue. We're all, of course, hoping that the minor issue may be eliminated and that may open up eligibility to a lot of people currently blocked by it. So the four categories that are currently being impacted and blocked by the recent changes in the laws or the interpretation of law, as is the case of the minor issue, is number one, those blocked by the minor issue. Number two, those blocked by the 2-generation limit that we're seeing come out of the decree, and preventing us from going back to a great-grandparent or beyond born in Italy. And we've got minor children who are no longer automatically recognized and must qualify independently. And then we've got applicants in Italy who without that 12-month residency. So there are two potential ways, two sides of the coin where things could change. We've got the legislative side and the legal side. On the legislative side, this would be there actually being some loosening of restrictions or some guidelines or some legislation implemented that would loosen up some of these restrictions and allow people to apply that are being blocked. So we've got, again, Decree Law 36 being converted as Bill 1432. And we've got all these amendments in place that would seek to potentially legislatively amend this decree law and those restrictions put in place by it. So that's one avenue where things could change and options could open up. Many people believe that the real objective was to get 3 generations removed, a generational limit of 3 generations, and that this emergency decree setting 2 generational limit is really just a bargaining chip. We say 2, the other side says 4, we settle on 3, and they get what they wanted all along by settling on 3. Again, a number of the amendments are moving in that direction. Some political pressure from inside the governing coalition is potentially moving things toward that 3 generational limit. So that's a place we could see a legislative change. And then we've got DDL 1450, which further could change things legislatively and create pathways for people that are currently blocked under the terms of the emergency decree that's in place right now. And the other side of the coin is the legal route, legal options. There are a number of potential grounds for challenges to these laws. Just the whole idea that many of us were born as Italian citizens under the eyes of the Italian law at the time we were born, and people are being retroactively stripped of that Italian citizenship through new laws that are attempting to be applied retroactively. So on your screen here are some potential options for legal challenges. There are many attorneys standing by and ready to start challenging these laws as soon as they're implemented, and some that are ready to start even right now before we even know for sure what laws are going to settle out and be implemented as. So, looking at the first category of people who are blocked, those blocked by the minor issue, again, we've got eligibility is eliminated for people whose Italian ancestor naturalized before their child reached the age of majority, reached adulthood. Now, this rule is based on ministerial interpretation. It's not written into citizenship law. It's not addressed specifically in Decree 36 or the conversion bill DDL 1432, and it is not also addressed notably in DDL 1450, which is a much more significant, well thought out document where they codify a lot of things into law, a lot of amendments, a lot of adjustments and additions to existing law, much more extensive document than the decree itself. And they did not choose to codify the minor issue restriction, the DDL 1450 even, again, which is the long-term plan for Italian citizenship moving forward, only talks about the idea that a parent must have held citizenship at the time that their child was born, does not go so far as to require that until adulthood. So that's really significant. Whether or not this provision will override the minor issue, we'll have to see how it's actually implemented, but is very noteworthy that they did not choose to codify that if that was their intention to keep that in place moving forward. So we've got some places, again, where the minor issue could change, looking at how the decree law is converted and implemented, as well as this subsequent bill, DDL 1450, is rolled out. So that's one place to look. Now, on the legal side of things, some legal scholars and advocacy groups have raised concerns about the minor issue potentially violating Italian Constitution and the EU Charter of Fundamental Rights. So we'll have to see if there are some legal challenges that crop up if the minor issue is kept in implementation moving forward. But did want to definitely touch on the minor issue because it is impacting so many people. But hopefully we see some legislative pathways around the minor issue, as there have not been a lot of successful challenges legally so far. But we will definitely keep watching the minor issue closely, as this is a huge issue for so many people. And the other big issue for many, many people is this two-generational limit. Obviously, we had, the vast majority of the Italian diaspora leaving Italy in this great migration in the late 1800s, early 1900s. So, with the exception of some people that are getting up there in years, there's not a lot of people that can go back to a parent or grandparent born in Italy, relative to the number of people that could go back to a great grandparent. So it's a significant impediment for a lot of people. It's important to note that, the decree law is just a temporary measure, and it may very well change moving forward. So we're seeing amendments already proposed on the legislative side of the coin, with DDL 1432, with the conversion bill. There are amendments aimed at proposing restoring eligibility for people that need to go back to great grandparents, including some potential provisions for those with stronger ties to Italy. We see that language in DDL 1450, which talks a bit about the idea of possible routes going back for those who had formal education in Italy, those who had a period of legal residency in Italy. There's a mention of a 1 year legal residency in Italy in the um, the illustrative guide section of DDL 1450, which I discussed in the previous video dedicated to that bill. There's a mention of cultural and linguistic integration, i.e., language proficiency. So there are some potential legislative changes very much could impact this 2 generational limit and soften it to 3 generations or maybe even more. And we're seeing, as mentioned, some pressure moving in that direction, even within the current government organization, even some dissent within the Tajani party, the minister who proposed the decree in his own party. We're seeing some other members feeling like perhaps the decree is too restrictive. So we could see some movement there on the legislative side of things. Going back to that slide, certainly also room for definitely, as mentioned before, there's room for legal challenges. Just the whole idea of constitutionality, of the legality, of implementing a retroactive 2 generational limit for those who were born under a with Italian citizenship granted to them under the laws at the time that they were born. Lots of room for legal challenges, and there will no doubt be many legal challenges, especially if the Italian government, does not create a legislative avenue for people now. They're opening themselves up for a lot of legal challenges moving forward. So, for that reason, we could see the 2 generational limit soften to 3 or more, and we could see windows of opportunity, such as time periods where anybody who wants to exercise their right will be given a window to do that, putting everybody on equal footing, giving everybody back their right to Italian citizenship. And then if they don't exercise that right within a certain period of time, then they lose it, and then it's much harder to challenge moving forward. So definitely something, we'll keep you abreast of. If a window like that opens, you'll want to take advantage of it sooner rather than later, and not miss out on that opportunity, as we may see a limited window of opportunity that will close eventually for people. The other category we talked about is minor children. So legislatively, what could change? Well, DDL 1450, again, actually, before we go back to DDL 1450, looking at DDL 1432, the conversion bill for the decree law, as I mentioned, we're seeing amendments seeking to give minor children back their automatic recognition of Italian citizenship. And we've got also that language in DDL 1450, which appears to propose restoring automatic inclusion of minor children at the time of their parents' recognition. We're also seeing legal concerns raised on the legal side of the coin about various elements, like that these rules may in some way endanger family unity, which is a big concept in Italy. They have a lot of laws on that subject, and there are potential violations of EU and Italian constitutional protections of minors as well. So some of the reforms could allow for joint applications, grace periods, restored automatic transmission, things like that. So there are, again, definitely both legislative and legal options that are potentially going to be available um, to those minor children who are blocked by the current restrictions in the decree. And then finally, the fourth category that we discussed was those applying in Italy. We mentioned that Decree Law 36 talks about a requirement for those applying in Italy on the comune level to legally and continuously reside in Italy for 12 months before applying. Some of the amendments proposed offer exceptions or grace periods to that, especially for applicants already living in Italy and those with families and minors or hardship situations. Again, looking at family unity. And there are legal concerns about the retroactivity of this rule, violation of certain principles, as is the case really across the board with many of these restrictions set up by the decree. So again, all four of these categories, we really see both some legislative potential for pathways to open up, as well as legal challenges if those um, are not these pathways are not opened up through the legislation. So what's still unclear is exactly how these effective ties will be defined or proven. That are mentioned in this language is kind of a theme moving forward with the bills, the decree, the conversion bill, and DDL 1450 having some sort of effective tie with Italy as a significant concept and a theme of these law changes and proposed law changes. So how exactly that will be defined or proven is still a bit unclear. Which of the DDL 1432 amendments, if any, will be accepted, and whether or not DDL 1432 and the decree law will even be voted into, converted into law. The assumption is that it will be. There's a good chance it will pick up some amendments along the way and will be modified from what is currently in place. And then we've got DDL 1450 bringing up the rear. And again, we haven't really even, they haven't really gotten into looking at that bill or discussing it because all of the effort has been on the decree law and the conversion bill, DDL 1432. So DDL 1450 possesses a lot of potential to be even much more impactful than the decree ultimately on Italian citizenship by descent over the long run. So whether or not that bill will pass or significantly change and exactly how all of that will be implemented is still TBD. So all things we're going to be looking out moving forward. So what you can be doing now, well, if you qualify under the decree law, under the current restrictions of Decree 36, you should strongly consider applying now through a consulate or court or potentially the comune. But remember, we do have that 12-month requirement for living in Italy before you can apply with the comune. So that may be challenging for a lot of people. But if you have a consulate case, consider trying to get an appointment with your consulate. We know that that's very challenging, as any of you who have tried know. It can take a year or two or more to get an appointment at the consulate if you can get one at all, and that can be challenging. There are court routes, especially for those who have the 1948 cases. There are potentially some other court routes that are available to people, so it could be a good idea to get a consultation, understand exactly what your options are so you can move as quickly and expeditiously towards the right window of opportunity for you. Again, something that I haven't mentioned yet in this video, but has been mentioned in previous videos, is the idea that Italy is proposing, as part of all of these legal proposals, to create a centralized office in Italy to handle applications moving forward. So those of you who are looking to start the application process now, we'll have to see whether or not you actually make it through applying at the consulate that has jurisdiction over where you live, or if ultimately you'll be applying through this new centralized office. The date of January 1st, 2026 was proposed for setting up this office, but a lot of doubt exists on whether or not it is in any way possible for them to set up staff and transition to this centralized office to handle all of these tens of thousands of applications, many tens of thousands of applications within, what are we at, like 7 months from now. So likely consulates will be continuing to process applications for a while until that handoff can take place. Now, if you don't currently qualify under the limitations of the decree, well, you still want to consider moving forward and consider gathering your documents and preparing for one of these legislative or legal windows that we've discussed in this video to open for you. Again, with each of these sort of main categories of people that are blocked there is potential for windows to open for each of those eventualities. So consider gathering those documents and preparing your case, and be ready when a window of opportunity opens. You'll want to track developments related to DDL 1432, 1450, and the various inevitable legal challenges that are coming up. And why you want to be ready to apply quickly. Well, if you look at how challenging appointments have been to get at the consulates over the years, and the fact that most consulates are currently heavily backlogged, especially with a temporary shutdown that has happened as elements of this decree have been figured out and settled upon. We're going to even see more of a backlog. Now, if we take into consideration the centralized office proposed to potentially be operational in January of 2026, you're currently, people are really, really struggling to get appointments at the consulates, and they're only competing essentially against other people who live in that consulate, the jurisdiction of that consulate for those appointments. If we start looking at a centralized office in Italy, well, now that could be subject to global demand. And just looking at, some of the numbers we've got, in the United States, all of the consulates combined, the Italian consulates handle about 3,000 applications per year. Of course, there are many that go through the courts, but just looking at the consulate appointments, the U.S. combined is only doing about 3,000 a year. Whereas, some of the countries that have a much higher percentage of the population with Italian ancestry, like Argentina, like Brazil, those countries are doing upwards of 30, 40,000 applications a year. So it's a significant difference. So if we're looking at a centralized office where the entire world, the entire Italian world is seeking appointments, as you can imagine, it could be even more challenging to get appointments. The wait times could be significant, and there is language of restricting the number of applications that are done every year. So it could be challenging. So pretty strong, compelling reasons why you want to be one of the earlier people to apply when a window opens for you rather than one of the later ones. So if you need help, there are ways you can move forward and prepare. You can have your case reviewed, get clear on your eligibility and the best path forward for you. You can get expert help gathering your documents and moving more quickly on all of that. You can do all of it without paying tens of thousands of dollars, $8, $10, $12,000 or more to large agencies. I'm meeting with multiple people every week that are coming to me after they've had a consultation with one of these agencies that's quoted them $8, $10, $12,000, and they just can't believe that it should cost that much, and it really is unnecessary. Even if you have a court case requiring an attorney, which most people do not need a court case or an attorney for the Italian citizenship process, Italian citizenship by descent. But even if you did, if you had a 1948 case, there's no reason for it to cost, $12,000, $14,000. And you can get personalized, efficient support from start to finish. So if you have questions, you need help, or you want to learn more about if you qualify, you can take advantage and book one of our affordable 20, 30, or 60-minute consultations at italiandual.com. I look forward to speaking with you, and I will see you in the next video. Thank you.